Good evening and welcome. You're watching NDTV and Vedant Agarwal. Big focus at this hour on NDTV. Well, the Punjab and Haryana High Court has set aside the Haryana government's law that promised 75% reservation to locals in private jobs. Of course, these jobs which have salaries of less than 30,000 rupees per month in various privately managed companies, societies, trusts, firms. So this comes as a big setback to the Khattar-led government in Haryana and also to the JJP, because this of course was one of the huge political planks as well. In fact, a group of industry bodies actually petitioned the court, and they said that this is an infringement of the employer's constitutional rights because ultimately in private jobs and in the private sector, employment should be based on skills and education. This is what the core essence of the argument of the petitioners was. And now the Punjab and Haryana High Court has set aside this law that promised 75% reservation for locals or domicile reservation. And of course, this also comes at an interesting time, at a time when we're looking at caste surveys in various states, at a time when in election-bound states as well, political parties are promising, caste surveys and subsequent reservation as well. At such a time, the Punjab and Haryana High Court has said that this is, in a sense, unconstitutional and not constitutionally valid. So this is a huge story, something that will have an impact on private job seekers as well. There are mixed responses coming in, but of course a huge political issue in Punjab as well. Joining me now, Senior Advocate Aryama Sundaram, somebody who has very important sort of insights on such cases. Thanks, Mr. Sundaram, for joining us on NDTV. My first question to you: how do you look at this judgment by the Punjab and Haryana High Court? Because in a rather strong observation, the court has said that this, in a sense, is not constitutionally valid. The 75% reservation for locals in private jobs is unconstitutional. How do you look at this?
Look, there are three aspects to this whole legislation. It did three things. All of three are questionable. Number one, reservation in private companies, which would then raise a question whether when a private company, a person in the private sector, has a constitutional right under Article 19(1)(g) to carry on his trade or business, whether this is a reasonable restriction on him to make him decide to decide for him who he can employ and who he can't. This is number one. The second questionable issue is, even assuming those to be reservation, can there be local reservation, thereby bringing a regional bias, whereas that goes against the basic concept of common citizenship? And it's the right of every Indian to do trade and business throughout India. And then when you say, no, only the local people will be employed in this state, you are then going away completely from treating the country as a union, which we are, although we are federal in nature. And basically, you are excluding citizens of India merely because they don't reside in your state, and that itself would be unconstitutional. The third issue, of course, is the quantum. 75% domicile quota is not something which would be acceptable. Any kind of reservation, even when we have reservation for backward classes, reservation for SC, ST, everything, Supreme Court has time and again said you cannot exceed 50% reservation, even there. Now, if you bring about a form of reservation where the rule is reservation and the exception is an open category, I think that itself is questionable. So I think there are three different grounds on which I would feel that this legislation was completely unconstitutional.
That's very important. That's a very important point there, Mr. Sundaram, because as you said that it's unconstitutional with respect to the employee, unconstitutional with respect to the employer, and of course, in the larger context of the 50% cap that the Supreme Court has very strongly advocated for as well. So do you think, the kind of observations that the court made in this particular case, do you also think that this is a welcome sort of move towards a meritocracy? Because all these industry bodies also said that, ultimately private jobs are based on education and skill and, the employees' qualifications. So that is something that cannot be infringed upon. So this sort of reservation and politics that comes into play, in terms of private bodies and industry, that is also something that the court has sort of come down heavily on.
Absolutely. You see, the point of the matter is that the rule is meritocracy. But the Constitution itself provides within the fundamental rights an exception to the rule under Article 14 against discrimination by making constitutionally valid reservation insofar as scheduled caste, scheduled tribe, backward classes are concerned. But that reservation is qua government employment, public sector employment. Bringing in that reservation into a private sector and into industries is not something which is constitutionally protected under the Part 3 of the Constitution. So therefore, if that is not something which is provided for within the Part 3, which deals with fundamental rights, then how do you violate the employer's right under Article 19(1)(g) to have a freedom in the conduct of his business? And how can you impose on him a decision as to who he can employ, who he cannot? Meritocracy, yes, we do make an exception in India for the purpose of helping the downtrodden over the years. But that exception is so far as government employment is concerned, so far as education is concerned. There are various aspects, but that cannot be extended across the board to include the private sector also. And surely a person who has invested his money into running a business, an industry, whatever, and creates employment can't be told who to employ and who not to employ.
Right.
The government can do that so far as its own employment is concerned for a larger social public purpose.
Absolutely.
But that cannot be imposed on a private sector employer.
Exactly. So we need to look
And
at
this
it in
other
that
thing
context
is very
as well.
worrying. This regional bias of employment. You see, this is also not a reservation based purely on factors of social backwardness or economic backwardness. This seems to be something to help local people.
Yes.
But then we are a union. India is a union. We have all the states. Every citizen has a freedom to move from any state to any other.
The petition also says
and
that
to
in
tell him
a
you
sense
can't be employed
violates
in this
common
state. So
citizenship.
Tamil Nadu says the same thing tomorrow. Telangana says the same thing. What are you saying? Are we splitting the country in this way? Yeah, I don't think that's correct at all.
Yeah. In fact, the petitioners also say that it in a sense violates common citizenship as well. And as you said, we do have domicile quota and domicile reservation in, say, government colleges, etc. But we are talking about private enterprises here.
Absolutely.
And we need to be mindful
and
of that as well.
Domicile, you cannot bring in domicile to the extent of 75%. What is ought to be done?
Absolutely. Mr. Sundaram, do stay on with us. I'm also being joined by Mohammed Ghazali, who is joining us live from Punjab. So, Ghazali, first of all, take us through the details of the petition, because these are industry bodies that petitioned the court, and they talked about various aspects of why this is constitutional infringement. But at the same time, this also has wide-ranging political ramifications. This was sort of bandied around as one of the most important political planks of the JGP as well by Dushyant Chautala. What is going to the political fallout? We already have reactions coming in.
See, there were two reasons why this law was brought in. The suggestion or the background of this law was that perhaps the low-paid jobs bring in more migrants to the state, which also endangers societal life as well as ecology. This was one of the background given before placing this law in the assembly, before tabling this bill in the assembly in 2021. Now, the second point was that we have seen in the past multiple annual data of CMIE, the center which monitors the unemployment or employment rate in the country, which has put Haryana repeatedly in the last 4 or 5 years on top of the list when it comes to unemployment. Now, this law was brought in 2021 when farmers' protest was at its peak. Youths from Haryana and Punjab had joined the protest there in Delhi in numbers. And since JJP is in coalition with BJP in Haryana government, they were seen siding with the farm laws, and then it was also understood that many youths, even in the rural areas, people were weaning away from the JJP, which is a party which boasts of raising the state-centric issues, which is a regional party. and hence this law was brought in to sort of fight all these issues, bringing back the Jat community into that community which was spearheading the farmers' agitation in Punjab, which happens to be the core vote bank of JJP, the rural vote bank. So to put them back into the spot in their own kitty, and also to address the issue of unemployment, the Haryana government brought this law, and this was actually, the credit was taken by JJP, the coalition partner, Dushyant Chautala, who happens to be the deputy chief minister in the state. Now with this, the judgment has come at a time when both the parties are contesting elections in Rajasthan, but separately. They're not in alliance there. JJP has fielded its candidates in Rajasthan on multiple seats, and now the judgment has come at a time when it's almost a year to the Haryana's assembly elections, which will happen next year after the Lok Sabha election. Now this could have been one of the major poll planks of JJP, because there are still murmurs of rift between BJP and JJP. Multiple leaders have said that we should go or contest the next assembly elections alone. Even in one of the recently held, you can say, rallies of JJP, there were sort of these slogans of Mission 2024, and we have to make Dushyant as CM in 2024.
Right.
So amid all this judgment will prove to be a big setback for the government, and we'll have to see Haryana government how vehemently they defend it or challenge it in the Supreme Court, because the issue was brought in the Supreme Court earlier. From there it was set aside, asking the government not to take any coercive action against the industrial bodies and put the law in abeyance. And it also asked the High Court to expeditiously start the entire trial in this case, or
Right.
pronounce the verdict in this case. Now, at a time it has come when JJP is trying to also expand its feet in Jat-dominated belt outside Haryana. So it is certainly a big setback. We'll have to see that what legal recourse the Haryana government will take in this issue.
That's right. And also, the legalese and sort of the politics aside, how do people in Haryana sort of look at it? Because ultimately it's going to impact them, it's going to impact the locals of Haryana. How do people, job aspirants actually look at this law?
See, the job aspirants certainly were very happy with it. They were very convinced with the law, because the reason being that Haryana has been reporting highest rate of unemployment in the country in multiple surveys by private agencies and the ones who record the unemployment rate in the country. And we also know that most of these industrial parks or industries or major factories or IT companies are based in Gurgaon and Faridabad. So the biggest resistance also came from the industrial associations which are active in Faridabad and Gurgaon. And they also had the same logic which the government was using for implementing this law, that it is all about the life and liberty of a citizen. Now, the industrial associations which had filed the plea in the High Court, they said that it is actually against this law, because it also discriminates against the federal structure of the country.
Right.
That somebody from one state cannot apply for jobs in the other state. So it is actually against the federal structure. The youths of Haryana were certainly convinced for it, and they saw an opportunity that perhaps this will bring down unemployment in the state, will give employment to the rural youth, because it must be noticed that this job was for vacancies which offer a salary till 30,000.
That's
and
right.
It was applicable on not only companies, trust and everyone, with a minimum workforce of 10.
Rehat Ghazali, thanks so much for joining us with that ground update there. Mohammad Ghazali reporting on the fallout of this decision of the Punjab and Haryana High Court. Mr. Aryama Sundaram is back with us on the broadcast. Mr. Sundaram, as we were discussing earlier as well, that reservation cannot be the norm, as you said, and meritocracy has to be the norm in a sense. As it's talked about freebies as well, though I don't know if it's comparable, but many say that freebies are a bad economic decision. So do you think this kind of reservation, we're talking about 75% reservation here, do you think it also compromises on quality? Because ultimately it may benefit parties politically, but what do you think is the fallout in terms of quality?
Look, without a doubt, this reservation and offer of reservation is a political plus for a party. From Tamil Nadu, for example, time and again the government has brought in reservation of 69%. And time and again it has been struck down by the Supreme Court. But they do this every time there is an election. Why? Because it is a populist measure. So reservation, and the more reservation you give, you go on the basis of there are so many people from a backward community who are going to be voters and therefore reservation. Of course, it's a political. And in many ways, all the states, Telangana wants to do the same thing. What Haryana is doing, Tamil Nadu has always been doing it, almost all the states where they find that reservation is going to be populist measure, will want to bring in reservation. There's no doubt about it. But that has nothing to do. Populism does not have anything to do with constitutionality. The right of a political party is to do everything in their power to come to power, so far as it's constitutionally valid. If they make a promise which is not constitutionally valid, the courts are there to step in, as they have done in the case of Haryana. So while the Haryana decision very clearly brings out the unconstitutionality of what has been done, I don't expect that governments will stop doing it. When there's an election coming up, they will do it. It is populist. They'll continue doing it. And the courts will also have to interfere.
In fact, Mr. Sundaram, what's very interesting, it's across party lines, because I was just reading the Congress manifesto that was released today in Telangana, and they have promised 75% reservation for locals in private sector jobs. So it actually is not confined to any one party. All of them have jumped onto this bandwagon.
Not at all. I'm telling you that take the state of Tamil Nadu, whether it was the ADMK in power or the DMK in power, they both bring in the 69% reservation. They both bring in a legislation knowing it's going to be struck down by the court, but bring it in nonetheless because it's populist. Now, Telangana, as you were saying, that's a Congress manifesto. Yeah. So in every single state across political lines, this is a political, you use the word freebie, I would say a political offering to people to say, look here, vote
steer
for
clear
us.
from the word freebies, because it's loaded with a lot of sort of political innuendo these days as well. But my last question to you, Mr. Sundaram, would be, just looking at this concept of domicile reservation or reservation for locals, what is the argument behind it? Because, as many would say, that reservation for backward classes, reservation for castes that have been historically oppressed, that is, in a sense, justified to sort of undo the wrongs of history. But what is the argument when it comes to domicile reservation, just to sort of understand the issue better?
Look, let's understand one thing. The Supreme Court has had occasion to consider domicile reservation in the past and has struck it down, saying that it's not correct. But the fact of it is, there could be areas where domicile reservation is justified. I'm giving you an example. You take the state of Himachal Pradesh, for example. There is domicile reservation sought to be given for teachers in various areas which are very difficult to access, hilly areas, where also knowledge of the local custom, knowledge of the local people, all this becomes relevant. In that case, there may be some justification to say that, look, this is really in the larger interest. But even there, I don't think you can ever extend it to the private sector. There's no question of the private sector. It's a different matter. For example, we've recently had an issue where the Maharashtra government has sought to bring in, for the purpose of the qualifying exams, sought to bring in also a paper in the local language,
right?
Which people are challenging, saying, how can you bring in the local language, in which case you're leaving out. So justification sought to be given is that, look, people who are joining these like consumer courts, like the district consumer courts, the people there in such small courts and out in villages and in small districts, they only know the local language. Right. So therefore, someone who knows the local language it'll be useful. So you can justify it on grounds like that, but never 75%. That's out of the question.
Absolutely. Mr. Sundaram, thanks very much for joining us, of course, with that very important perspective and very holistic perspective there. Really appreciate your time. Mr. Aryama Sundaram there speaking to NDTV on what the ramifications of this could be. Remains to be seen what legal recourse does the Haryana government take.